Hello everyone, welcome to another episode of our channel Law Point. This is your host Renu Thomas back again. Judiciary ensures the supremacy of law, protects individual rights, settles conflicts and prevents democracy from becoming an authoritative or doctrinal regime. But what if anyone questions the authority of its supremacy and lowers its dignity? But how can judiciary protect its interest in this scenario? We'll get to know about this in this episode. We have with us our Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph, to explain the same. So let's watch this episode.
The judiciary safeguards its dignity and authority through Contempt of Courts Act of 1971. The contempt of court means misbehavior of any person in the presence of judges, interfering with court proceeding, disobedience to the order passed by the judges, etc. There are two types of contempt of court: civil contempt and criminal contempt. Now let's see what is civil contempt of court. Civil contempt means when a person disobeys the order of the court or willful breach of an undertaking given to court, then it amounts to civil contempt. For example, after hearing a case between school management and a complainant student, the court finally decides the matter and directs the school management to admit the complainant student. Then, if the school management is not admitting that complainant student, then this amounts to civil contempt. Another example is if there is a case between government and a retired employee with respect to the question of granting of pension. The court, after hearing the parties, finds that the retired employee is entitled to pension. Then the court directs the government to pay pension to this retired employee within a period of 2 weeks. Then, if the government is not paying him pension within this prescribed period of 2 weeks, then it amounts to civil contempt. Yet another example of civil contempt is while granting conditional bail, the court lays down several conditions to be followed by the accused on bail, like reporting daily to the police or do not leave the district without the permission of the court, etc. Now, if the accused is not reporting daily to the police or he leaves the district without the permission of the court, then it amounts to civil contempt. Here, first two examples deal with disobedience to an order of the court amounting to civil contempt, and the third example deals with willful breach of an undertaking given to the court, which amounts to civil contempt. Now, let's see what is criminal contempt of court. Criminal contempt means publication of any matter which scandalizes or lowers the dignity or authority of court or interferes with the administration of justice or obstruct any judicial proceeding, etc. For example, through social media like Facebook, Twitter, or through newspaper or through TV news channel debates, if any person makes a comment that the judiciary is a corrupted institution or judges are all corrupted or biased or they are all servants of the government, etc., this amounts to criminal contempt. Another example is while a court proceeding is going on, a person shouts or uses abusive words or misbehaves with the judge, then that all amounts to criminal contempt. In both civil and criminal contempt, the Contemptuous Act lowers the dignity and authority of the court. However, in civil contempt, the disobedience is to an order passed by a court in favor of a particular party. Whereas criminal contempt, the comment or publication is directly to lower the dignity and authority of the court. A person convicted of contempt of court may be punished with simple imprisonment for a period of 6 months or with fine of ₹2,000 or with both. However, if the condemner remits unconditional apology to the satisfaction of court, the court can condone him. When contemptuous acts or words alleged to have occurred inside a courtroom, then that particular court can take action of contempt. However, if the contemptuous act alleged to have occurred outside a courtroom, then it is for the High Court of each state or the Supreme Court of India can only take action of contempt. Now let's see what are the defenses of contempt of court acts which does not come under the category of contempt of court. First defense is the condemner did not have knowledge of the court order passed by the court. For example, the condemner was not a party to the litigation and he did not know anything about the court litigation and the order passed by the court. Then in this particular case, the contemptuous act does not amount to contempt of court. However, the court examines whether the condemner had knowledge of the court litigation and he had not taken any effort to understand what the content of that order passed by the court. Now, in this case, the condemner is liable for contempt of court. Now, the second defense is if the contemptuous act was done accidentally and not with an intention to disobey the order passed by a court of law. For example, if the court directed an officer to do a particular thing in a particular manner, then the officer, without understanding the order in its correct perspective or misinterpreting the order, has done the thing in a different manner, then this does not amount to contempt of court. Another defense is if the order of the court is impossible to perform. For example, the court directed the possession of the house to be handed over to a particular party. However, that house got destroyed by flood. Then now this order of the court is impossible to perform. Now this is a valid defense for contempt of court. Another defense of contempt of court is the order passed by the court is vague. For example, details of the person to be arrested is not clearly specified in the order and the police arrest someone else. Then this does not amount to contempt. Another example is particulars of the properties to be attached is not clearly specified in the order and the officer attaches some other property. Then this also does not amount to contempt. Fifth defense is if a person publishes or comments a true and correct fact and the court is satisfied that it is for public interest or in good faith, then this also does not amount to contempt of court. Sixth defense is a fair and accurate reporting of a court proceeding does not amount to contempt. However, if there is a clear direction from the court that there should not be any reporting of the court proceeding, yet if there is a reporting of the same, then this amounts to contempt of court. Further, if there is in camera private proceedings in court which is reported, that also amounts to contempt of court. Another defense is fair criticism or fair opinion on the merits of the case that has been conclusively determined by the court does not amount to contempt of court. These are some of the defenses of contempt of court. Thank you.
Thank you for watching. Meet you in the next episode. Stay tuned.